Please be seated. Okay, the defense may make its final argument.
Your Honor, Counsel, Ms. Potter, ladies and gentlemen of the jury, I have not argued a case with a plastic shield in front of me before. This will be a first, hopefully the last. But before I get into my final argument, or summation, some people call it, we apparently were accused by the state in their argument that we might run you down a rabbit hole of misdirection. Rabbit hole of misdirection. That's what they said. Playing the video, not at the right speed, where it showed chaos, playing it as slow as possible, showing photos, that's the rabbit hole of misdirection. And make no mistake about it, Kimberly, Potter, Johnson, Lucky, and Wright were fighting, struggling, and it was in seconds that happened, not slow motion. So when you go into that jury room, play it like it's supposed to be played, not a rabbit hole of misdirection. Rabbit hole of misdirection, no threat by Daunte Wright. He broke free from a law enforcement officer and took off in his car even after he was shot. No threat. Sympathy for Potter? Well, what are the photos of Daunte Wright doing up there with his child? Does that prove anything on this case? Of course not. They're asking for sympathy, not us. Johnson not worried at the scene? In final arguments, you're to rely on your own memory of the evidence, and not mine, not hers, your memory. Well, that isn't what he testified to. Not worried, she says. No, could not see Johnson. Well, ladies and gentlemen of the jury, the body-worn camera is here. Her head's here. She didn't have the camera on her head, and when she's leaning in, of course the body-worn camera doesn't see Johnson. But her head does, and she testified she saw him, and his look on his face like she never saw before. That's the evidence. They have the temerity to talk about Stoughton, a man who had the power to charge up to $93,000, who doesn't remember being a police officer. When I ask him about crisis, he wants to go back to the training field. The temerity of saying that cops, because they're a family, lie. And then the spark test. She didn't do the spark test, so that's evidence of recklessness. What a catch-22, ladies and gentlemen. They also used the fact that she went to each and every training session, each and every one of them, and there was evidence from one person that she paid attention. Can you imagine if she, and they're using that to say she's reckless, can you imagine if she didn't go? Oh my gosh, they would call her criminal, reckless. She missed a session, but she didn't. And now they're holding that against her. What a catch-22 that is. So I'm not going to run you down a rabbit hole. I'm going to try to make a reasonable and sensible final argument based on the evidence. However, if my recollection is different than yours, rely on your recollection. You are the jury, and you have the power to disregard what any lawyer says if your memory is different. I'm not going to try and misstate the evidence. I'm going to try and state the evidence. Once in a while, lawyers make mistakes, just like anybody else. First thing I'm going to do, have a drink. First thing I'm going to do is talk to you a little bit about proof beyond a reasonable doubt and the presumption of innocence, because that was left out of the state's argument. And the presumption of innocence, it means what it says. Your duty, your constitutional duty, is as jurors to presume Kim Potter innocent. Not guilty, innocent. That she's innocent. And before you can find her guilty, you must find that each and every element of the charges is proven beyond a reasonable doubt. Beyond a reasonable doubt means what it says. It's a type of proof you'd act upon in your most important affairs of your life. And make no mistake about it, ladies and gentlemen. This is the most important affair of my client's life and ours. It's a type of proof, I believe, that 10 years from now, when you look at yourself in the mirror and you say, by golly, I did the right thing when I found Kim Potter not guilty of both counts. That's beyond a reasonable doubt. There's also one other constitutional right that's important, and that is a person's right to a jury trial. A jury trial like this. We have the state prosecuting, we have all government workers, and our forefathers believed that in order to find somebody guilty or not guilty, a jury, a fair jury, should be called, and they are the ones that apply the presumption of innocence and proof beyond a reasonable doubt. And that's your job. You have to enforce those constitutional rights. That's the constitutional right of a jury trial. Jury of your peers. A fair and honest, unbiased jury. When you're asked in your questionnaire, could you presume somebody innocent? Well, you all answered yes, or you probably wouldn't be on this jury. But when you think about it, which you probably didn't as much then, presumption of innocence is that she didn't do it. And every day of your life before this trial, I can't recall if any one of you has been on a jury before, but every day of your life, you read the paper, you hear on the news, the media, whatever, that they arrested somebody. And in your brain it says, oh, they got the guy. You can't do that here. That's not the law in a courtroom. It's outside the courtroom. In the courtroom, you must presume innocence, that my client is innocent, our client. And that's a very important presumption, and we'll get into that. So, and these constitutional rights were enacted a long time ago by our forefathers. And what they did to enact them at that time was to protect our freedom. Protect our freedom from overreaching government and from biased people and from mob rule. That, hey, you can't lynch that person. We're giving that person a trial. There's no mob rule, and we're going to be fair about it. So that's what we're doing here, ladies and gentlemen, the jury. We're giving Miss Potter a jury trial, and in that jury trial, we're going to presume her innocence, and we're going to require the state to prove each and every element of the crimes. And in doing this, I'm going to sort of categorize here. I'm going to get into the evidence right now. I'm not going to give a real lengthy argument, but the first category I'm going to talk about is causation. That's the first category. Let's look at the causation in this case. And to do that, we have to look at the instructions of the jury. In the instructions, and I got scribbling on there, but you'll get a copy of this back in the jury room, and it's extremely important. The importance is this. I'm going to read it. To cause the death, causing the death, or cause the death means that the defendant's act or acts were a substantial causal factor in causing the death of Daunte Wright. The defendant is criminally liable for all the consequences of her actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were a natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. Here's the however, and it's extremely important, particularly when the state argues that Daunte Wright had nothing to do with his death, which is absurd. However, the defendant is not, Kim Potter is not criminally liable if a superseding cause caused the death. What's a superseding cause? Is a cause that comes after the defendant's acts alters the natural sequences of events, and this is the sole cause of a result that would not have otherwise occurred. Let's look at that superseding cause. Let's look at the evidence. Substantial factor. What happened here? We got a Sunday afternoon in the spring, April 11th, and an FTO officer, my client, our client, and Mr. Lucky, Officer Lucky, were driving in their town, Brooklyn Center. They see a car that was going to do a right turn, but then decided to go left. They see the thing on the end windshield or whatever, and they also see that the license plate is not registered. Our client did say that she might not have even stopped them. But Lucky, Officer Lucky, who was a trainee, she was the FTO, wanted to stop him for the thing hanging on the window and the registration. He first saw that thing on the window, and then when they got closer, they saw the registration, or they checked on it. In any event, they stopped them. That everybody agreed that was a legal stop. They were doing their job on Sunday afternoon in Brooklyn Center. After they stopped, Lucky and my client got out of the car. Lucky went up to the door. You heard, and you can listen to it again, hopefully at the right motion and not slow it down until forever. Do it at regular motion. He goes up there. He says, "Hi, bro," something like that, very nice. Asks him for his insurance and driver's license. I think he tells him something about the thing hanging on the window, on the mirror. And he doesn't have a license. He doesn't have insurance. And he gives him an insurance card with somebody else's name on it. And Lucky smells marijuana and sees some in the car. Well, that's consistent, because as you learned, he smoked a joint with his passenger that morning when they got up early. And I asked what time. Well, 10 o'clock in the morning was early for this couple. But after that, they smoked the joint. And what's even more corroborative of that is the forensic pathologist says 4.3L, I believe it's something like that, is a high reading. So we know now that circumstantial evidence, which you'll see in the instructions, reasonable inference, he has that kind of reading, he's stoned. He's got marijuana smell in his car. He's got seeds on the floor, shake, Lucky called it. So Lucky goes back to his car, and Kim Potter goes back. They go in the car and they do a warrant check, that's legal, that's proper, that's their job, that's what they're supposed to do. And lo and behold, Daunte Wright has a warrant, a bench warrant. In other words, he didn't show up in court for a weapons violation. As Lucky said, that raises the antennas. Oh, there might be a gun in this car. And Lucky said, and he grew up in this neighborhood, he said that 2 in 5 cars have guns in it. So that raises the antenna for these two cops. In the meantime, they called for assistance, which is regular police work. They do that even on a traffic stop. And Sergeant Johnson shows up. So we now have the 3. And they see that there's marijuana, no license, no insurance, a warrant, a bench warrant for a weapon, and a TRO, or restraining order, where some lady, accused him of harassing him. That's what we had. That's what these police had when they walked out of that car. When the 2 walked out, Sergeant Johnson was already right there. And they go up to the car, and everything up to this point, Kim Potter's acts, Lucky's acts, Johnson's acts, are all protocol. They did everything right. And once Lucky gets up to the car, he tells Daunte Wright to get out of the car. Daunte hesitates, says why. I believe the evidence shows, if you listen, if it does show it, that even his passenger said, go get out of the car. But anyway, he hesitated, and he said, why? And then he got out of the car. And Officer Lucky, being a nice guy, I mean, he could have taken him and thrown him against the car and put his knee on his neck. No, he said, put your hands behind your back. I'm going to handcuff you. And at the same time, Sergeant Johnson says, you have, and he wants to know why, you have a warrant. Now, Daunte Wright realizes there's a warrant for his arrest. And he knows what it is. So, within seconds, he all of a sudden breaks away. That's the cause, ladies and gentlemen of the jury. That's what caused this whole incident. If he would have gone and with the officers, been handcuffed, go to the squad car, go take your ride downtown, and it's over. That is called, as the law states, a superseding cause caused the death. Because everything after that, the officers did, they did to try and restrain him, try and stop him from leaving. And don't listen to Stout. This Stoughton guy saying you should just wave at him and say goodbye and let him go. With a weapons bench warrant, with a temporary restraining order, he's stoned. You don't let that, that's not protecting the public, and that's not serving the public. They had to stop him. And he watched the video, and he's fighting. My client, our client, goes around Lucky and grabs her gun instead of her taser. She thought, and I don't think there's anybody here, even the state, would contest the fact she thought she had a taser. It was within seconds. You watch it. It was chaos. She's going around here, and Johnson, he's in the car now, holding on to the shifter and onto the key, and then he grabs Daunte Wright's arm. And, you know, I once mentioned in this case, and I got a little giggle, I guess, from the state. I said, what would have happened if that car would have went in reverse? Oh, it wouldn't go in reverse. He couldn't go in reverse because there were squad cars back there. Well, what about if it accidentally, from the park position, accidentally went down to reverse when he was struggling to get it in drive? What would have happened then? A very dangerous situation for everyone, the officers and Wright. So they're fighting. They're struggling, whatever you want to call it, and Wright's putting up a good struggle. He doesn't want to go to jail. So Kim Potter, I got the seconds, where Kim Potter comes around and she says, I'll tase you. Now, all the time before that was police work, good police work, trying to stop him from leaving. And then she comes around and tries to de-escalate, it's called, the situation by saying she'll tase him, thinking that she had her taser. Why didn't he stop? Two cops are fighting with him. There's another police officer that's saying he's going to tase him. He didn't want to go to jail. He wasn't going to listen to these police officers. 4 seconds later, and you'll see this, and make it chaos, because don't slow motion it, make it at the right speed. She says again, to de-escalate it, to say, hey buddy, stop, I'm going to tase you. Nothing happens with him. He fights, he struggles more. Watch the video. And then, a couple seconds later, I think 4 seconds, I believe, she says, taser, taser, taser. And he said, okay, stop, I give up. No. Would she have tased him if he ever said that during those seconds? That he was struggling, that he wanted to leave? Would he have said, I'm not going to go, I'm not going, handcuff me, I'll go to jail? No. And that's the cause. That's everything before that the police officers did as they were supposed to. In fact, it was a very procedurally right reasons for them. So, the causation get my notes here. The causation was Daunte Wright. And, sometimes things happen that are unexpected, but they save a life or they save serious injury. Because when Kim Potter said, taser, 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 that's a signal for the law enforcement officers to take their hands off him, which they did. And then a second later, she shot him, tragically. But she didn't know she had a gun either. And then he said, you shot me. And being alone, what does he do? Does he stay there and say, hey, help me out? He takes off then. And you see the video, he goes like a jet. He drives in danger, he's shot, he drives in danger. He really wanted to get away. And what you can reasonably infer from that, you can reasonably infer that he knew he was guilty of that weapons violation. And he didn't want to go to jail and run the risk of a criminal case. He left to get out of there. Unfortunately, and he was able to leave. He said, you shot me. He drove down. The forensic pathologist said he could have been alive for up to a minute. So you heard the crash. I believe it was about 10 seconds that the crash happened when he took off down the road. And that, what's really interesting here, and I don't know, you're probably wondering a little bit too, but why are we watching all this stuff about the car accident? Why is that part of this case? Kim Potter didn't drive that car down there. Kim Potter didn't tell him to drive that car down there. He, on his own volition, while he was alive, drove down there. He should have stayed. Maybe he would have had some medical help from the officers Potter, Lucky, and Johnson. Think about it. Yet they show all of this. They show the poor ladies, the lady, Miss Lundgren, and her husband's and physical health, bad physical health. They show that. They show her daughter, and it's all got nothing to do with this case. But you know why? You know why they're doing that? They're trying to run you down the rabbit hole, as she says. They want sympathy. They want sympathy. They want to blame that on our client. Think about it. How could she be at fault for that? He purposely decided to drive away. He just didn't want to go to jail. So that's the superseding cause. The judge will instruct you. As it is here, it's the last sentence. I'm not saying something that's not there. A superseding cause that comes after the defendant's acts. Her acts were all legal. Everything she did was legal. And then he tries to break away. And consciously, she thought she was doing the right thing. So the state, that's an element too, by the way. I don't know if I mentioned that, but the element for this case, for both crimes, is second, the defendant caused the death of Daunte Wright. Kim Potter caused the death of Daunte Wright. The death of Daunte Wright was caused by the defendants committing a reckless handling of a use of firearm. Caused. And that's in the second elements of manslaughter too. The defendant caused the death of Daunte Wright. So I could stop right here, because if you presume what you have to do, if you presume that she did not cause the death, which you have to do by the presumption of innocence, did they prove beyond a reasonable doubt that she caused this death? No. Daunte Wright caused his own death, unfortunately. But those are the cold, hard facts, the evidence. So I could sit down now because they didn't prove that element, but we're going a little bit further. I apologize, it'll be a little longer. And the second issue that I'd like to talk about is the authorized use of force. And the authorized use of deadly force is the first defense. And the state has to prove that they have the burden, and I'm going to read it to you. The defendant is not guilty of a crime if used deadly force as authorized by law. This is important. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of deadly force was not authorized by law. And when you look at that, you also look at the presumption of innocence. And you must presume that she had a right, authorized use of deadly force, that she had a right to do it. That's the presumption of innocence, and the state has a burden to prove beyond a reasonable doubt that she did not. And the other interesting factor that wasn't mentioned is that you can't hindsight these things. You can't say to the officer, well, now, wait a minute. You didn't spark your gun or your taser. You went to all those training sessions, so you should have known it was a taser or gun, not a taser. It's not should have known. And we'll get to that. But let's first look at defendant's authorized use of deadly force. First off, there was a vague argument that the officers are a family. So they're lying. They're not telling the truth. They're helping Kim Potter out. They're a family. Come on. You saw all of these officers. Were they professional? Yes, they're college graduates. They came before you and told the truth. They weren't impeached by anything. A family? Major Johnson is no longer in Brooklyn Center. He's down in, I believe, Goodhue County, down in Red Wing. He's a major down there head of patrol. Is he the kind of guy that would lie about something? No. And the other officers? The commander. Is he part of the family? No, he knows her. He thinks he's a good cop. So to argue that these police officers gave their opinion because they wanted to protect Kim Potter, they know what the oath is. They know what a crime is. They know what perjury is. They're not going to do that. That's going down the rabbit hole, I believe. In any event, remember the auto accident? And there was this one picture, I believe, and Daunte Wright was lying on the ground. I think there were 6 or 7 police officers around him trying to revive him. Police officers aren't thugs. You've seen these officers. To say that they would color their testimony to help their friend out is outrageous. It's simply not fair. And as far as the authorized use of force, they paraded their own witnesses, the state's witnesses, Major Johnson. I asked him, well, were you in danger? I can't remember exactly what I asked him, but basically to show that he was in grave danger or might get killed by him wrestling with Wright while leaning over the car. Maybe he wasn't sitting in the car, but he's 6'2", leaning over and grabbing that shifter and grabbing his arm. If he would have been able to get that shifter going and get it going, what would have happened to Johnson? The worst would be death. If he took off like he did as a jet, the least would be serious injury. And when I asked him that, what did he say? And this wasn't contrived. It wasn't, no evidence that it was made up. He said, he quoted 60966, which is in the instructions. That on deadly force, he cited the statute. That's what he believed. That was his take, and he was there. He wasn't in a classroom or in Florida watching a video. He was there. He was the man leaning over and struggling with this guy. And when you're taken by surprise, all common sense, reasonable inference, when you're taken by surprise like Wright did, and you're relaxed before that, and you're doing these things, and all of a sudden you won't give up, that's chaos. That's chaos. And Johnson was in there. And Stoughton can say what he wants, but what did James say? After hearing the testimony of Johnson, no question that Officer Potter had a right to use deadly force. Even though she didn't know she was using it, she had a right to. And that's what the law is. And they have to prove beyond a reasonable doubt that she did not have a right. And what do? The only person they call is Stoughton, the $95,000 contract a year guy. Stoughton, who is not a cop for 15 years. He was a police officer 5 years and doesn't remember if he ever had a crisis. He wanted to talk about field training. It's hard to believe our state of Minnesota would do that. Would hire some guy like that, and you compare him against James, 40-some years as a cop, all the things he's accomplished in his life. And Stoughton, and you have a right, there's an instruction, you have a right to compare like the believability. You can look at that instruction here about experts. You have a right to look at that. Their bias. Is there bias? I don't know. He gets paid, he can be paid up to $95,000. Our expert, he doesn't charge. He chooses not to charge. He drove up here having a heart surgery 2 weeks ago. That's how strong he believes in the fact that she could use deadly force. Lucky, he also, he was here, he was in it, he was involved in this struggle. He said that Kim Potter isn't going to jail. She's not going to jail. That's what he said. In his opinion, Kim had a right to use deadly force. But we don't stop there. Then we have Fuslin. Garrett Fuslin, a commander, been in the Navy 10 years, 21 years as a police officer. He's the commander at Brooklyn Center. And he said, on the hypothetical I gave him, and it was a hypothetical exactly, and you can check your notes, you can remember his testimony, the same hypothetical that happened at this scene. And he said, yes, she could use deadly force in that situation. That's two of their witnesses. Then we've got Gannon. We call Gannon the chief of police, ladies and gentlemen, a man who was in the Marine Corps, a man who fought in battle for our country, a man who wanted to give Kim Potter due process, and he got terminated for it. Think about it. He takes a stand. He gets the same hypothetical. Yes, deadly force. They have to prove beyond a reasonable doubt that she did not have a right to deadly force. We've just proven through 3 witnesses that she did under this circumstance. Do any of those officers, Chief Gannon, he doesn't work there anymore. The major doesn't work there. The commander, he isn't too worried about his job. Are they the kind of individuals that would lie, that would give a false opinion? No. Think about it. Look at the instruction on that. But we're not done there. I have another. There's 2 absolute reasons why she's not guilty. Absolute. She didn't cause this, and she had a right to use deadly force. We proved it. And all we have to do is establish reasonable doubt. They have to prove it under reasonable force.